greatest pleasure to welcome you here in Polish Academy of Sciences Scientific Center in Vienna. This is the second, actually, day of our conference, Assassins of Memory, Political and Legal Problems of Uncovering, Whitewashing, and Rewriting History. Of course, as you can see today, we cannot be gathered here in many people. We have a tough situation right now in Austria regarding the new pandemic rules, but still, nevertheless, I am really happy that we managed to gather here, that we managed to have this conversation live, and that we hopefully will have a fruitful discussion about the subjects that we are going on reveal regarding memory laws today. And of course, let me welcome all the speakers of today's conference. I know that some speakers will be coming later for the later sessions because we have 4 distinct sessions ahead of us. And of course, welcome all the guests who also like to come to our meeting today. And just a couple of technical information, because as I was saying, because of the pandemic situation, it was hard to gather audience live, but we decided to stream the entire event. So the entire event is streamed through our Facebook and YouTube pages. Actually, yesterday we had a fruitful and great online session that was also streamed and recorded. So if any one of you is also interested to hearing out that session, it's recorded, it's on our Facebook page, it's on our YouTube page, so feel free to watch it later. And the same will be with this event. It will be also recorded and will be possible to play back later at the later times. And just a technical information, I know that you probably would hear me very well also without the microphone, but because we are streaming this event, we need to use microphones so that our viewers can also hear us as well. So please remember always to switch on the microphone and also to switch it off after you've done speaking, because you know there can be some disturbances when it comes to the sound. And without further ado, I would like to ask for the stage Professor Arkadiusz Radwan, the director of the Polish Academy of Sciences Scientific Center in Vienna, who will share with you some initiating words for this conference. Professor Radwan, please.
Sonia, thank you very much. We all remember almost 2 years ago when the pandemic started and the sessions, meetings went from on-site to online. Many people at first were skeptical about this format, and also that typical welcome speech would refer somehow to this very unusual setting. And now, 2 years down the road, we find ourselves in a quite reverse situation. So we have some strange feeling about meeting physically, and I must take a note of this unusual setting in which we are meeting by the fact and for the fact that we are meeting physically. And as Sonia mentioned, well, this is actually my second welcome speech. I delivered the first one yesterday, as the first session was in our familiar manner online, and this one is held here on site in Vienna. Yes, precisely in Vienna, in this country, it was where some time ago, 2006, one of the most known Holocaust denialists, David Irving, was convicted 2006 for his statements made years earlier denying the existence of gas chambers in Auschwitz. Sometimes later, he was invited by the Oxford Union to speak in a way for a battle of arguments, for his allegations to be defeated on the stage in the academia. And actually, this invitation was in a way triggered by his earlier conviction, which in a way also made him a martyr of free speech. Now, this contrast of those two attitudes, one here in Austria of him being convicted, and in a way a provocative answer to this by inviting him by this noble society for a discussion. It is in a nutshell much of the dilemma of the academic discussion we are having, and we will be devoting our time and attention yesterday and today. And this is basically about how much regulation is needed and required and justified, and maybe a free market of ideas, free voices should do the job. Who should be the moderator of the discussion about the past? Academics, history professors, philosophy professors, supported by journalists and free media, or maybe judges, policemen, prosecutors, and legislators. And is there, or should it be, a universal answer to these questions? Or maybe the answer should be case sensitive. Maybe it should take account of different cultures, different social norms, and also, last but not least, very different experiences from the past. And when we see attitude that different countries take, we see some dividing lines. We see freedom of expression prevailing in the UK or in the US, and we also see a rise of legislation imposing certain restrictions on freedom of speech in many of the continental European countries. Even if we don't see this in this room, because we are not that many, and as Sonia mentioned before, pandemic imposes certain limitations, but still you must believe me, when we published a call for abstracts, we received a number of interesting proposals. We couldn't choose all of them, but it encountered an interest in Europe and beyond. And well, actually, I should say I'm happy about this, but the question is, should I actually be happy? Because of the fact that so many scholars devote their time to do research on the junction of law and politics. And we clearly see, and this is the question why I doubt whether we should cherish this development, that the politics of memory is on the rise. And contrary to intuition many could have who are not so familiar with the topic, if people would be asked about the origin of the legislation, anti-denialist legislation, many would probably sense it must have been enacted shortly after the war in the direct aftermath of these atrocities, because most of the memory laws or the first ones dealt with denialism of the Holocaust, and then other genocides that took place in the first half of the 20th century. Then later, when post-socialist countries joined Free Europe, obviously we've seen many laws combating negationism concerning communist crimes. But still, since the origin has to do with atrocities of the first half of the 20th century, many could guess this must be a development maybe of the 50s or the 60s, and which is actually not the fact. The legislation actually started off in the 90s and then proliferated in the past decades, and many democratic countries scoring well on the scales of freedom of speech have different legislation in place imposing limitation on certain statements. And we see this controversy, this dilemma. We see those two values. And we should be aware of the fact that whenever law meets history, they should approach one another with a lot of caution. And basically on both sides. Because on the one side, what history evidences and what history teaches us should not be denied by those who made this as their business model, to deny what happened, to maximize their political capital or their financial capital. On the other side, the law should not impose undue limitations on academic freedom, freedom of expression, freedom of artistic expression also, and, well, basic freedom for search for truth. So we see a struggle, a tension between those two values. And, well, if the law seeks to protect, then, well, the question is, what should be protected? The truth, the collective memory, or the good names of the ones who once in the past stood on the stage of history and cannot speak for themselves today because they passed away? Or should it be the public order, curbing hate speech, hatred against minorities, ethnic groups, and so on? Should it be a bigger goal, meaning to prevent history from repeating itself? Should it be moral capital of nations, that countries also in a way compete to maximize their moral capital? Should this be a moral commandment to rehabilitate some and condemn the others? So in the first place, it is not always so clear, if we decide for the law to interfere, what the law should actually seek to protect, because there are quite many possible values that we maybe should protect or not. And the question that adds up to those dilemmas is the following one: how can it be effective in the first place in a time of the rise of the social media, so many communication channels, and the times that are by some referred to as the post-truth era? Many questions, also some that relate to public perception. Even if we decide to interfere, how many of the public is able to differentiate between the judicial fact-finding, judicial reasoning, and judicial verdict, and the verdict of historians, the fact-finding, the methodology, and so on? What is the perception of a given judicial verdict? Many questions. And I'm very happy that so many distinguished scholars agreed to come and speak at the conference to discuss from very many angles, many experiences, national experiences, many countries, to discuss about this, because this is a topic that is not only this interdisciplinary. Undoubtedly, it is a very interdisciplinary topic, but I think it is one that actually can only be reasonably discussed at an international level. Why is it so? If we see the rise of memory laws across the globe, some of them are tools in different battles or competitions for political capital, moral capital, and so often they simply lead to a zero-sum game. If one country comes up with legislation telling who is the victim and who is the perpetrator and what is the only way to interpret history, the other nation might answer, might come up with their own legislation that contradicts the former. And basically, if one nation makes gains, it is so often at the expense of others. So therefore, I said it is often a zero-sum game. So probably if we should talk about the law interfering with history, the national dimension or the national level probably will never be sufficient, because it will steer many controversies. Maybe it will convince the convinced ones, reaffirm their confirmation bias, but at the same time steer controversies and heat up the political tension between the nations and the countries. And some of them we have seen the headlines of international press, and in some of them, Poland was also involved in a very recent past. So I'm very curious to hear your presentations, to hear your arguments, and discuss with you on this, I think, very valid topic. So again, thank you so much for accepting our invitation, and I'm very much looking forward to our 4 panels that are scheduled for today. Thank you so much. And having said this, I would like to invite speakers of our first panel that I will have a privilege to chair. Our first speaker had, for some family reasons, to resign. We were notified just in this very morning, so Dr. Astrid Krajzniak-Korasny is not with us. So please let me invite Professor Ireneusz Kamiński, yes, to join us here at the table. Dr. Filip Ciuńczyk and Dr. Klaudia Kurecidis-Haider. Okay, so we are moving to our panel. Our second speaker on the list, but our first speaker actually is Professor Ireneusz Kamiński, who represents the Institute of Legal Studies of the Polish Academy of Sciences in Warsaw. He is a renowned international scholar with hands-on experience with European Court of Human Rights in Strasbourg. He has written extensively on many issues concerning public international law, and specifically on the junction of law and history. So, Professor, we are very honored to have you here at our conference. And the topic of your presentation is the Strasbourg Standard for Forgotten and Unsettled Historical Crimes. Professor, the floor is yours.
Thank you very much. Can you hear me? Yeah, great, great. It's my great pleasure to be part of this conference. So thank you very much to the organizers for your invitation. I'm going to present you some case law, or precisely the position of the European Court of Human Rights with so-called unsettled historical cases. The European Court of Human Rights has very rarely dealt with this kind of cases, but they are very, very important for the convention system and for the foundation of the convention system, which is based on, some values, underlying values of the convention. And my story is complex, so I will provide you with more information in the written version of my contribution. Today, I only concentrate on key issues, and in order to facilitate you to follow my presentation, I prepared some slides in order both present you some factual, but also legal context. So let me start. Thank you very much. This building is the European Court of Human Rights in Strasbourg. And to start with, the European Court of Human Rights was considered to be a conscience for Europe. The Council of Europe and the European Court of Human Rights, the European Convention of Human Rights, were considered to be, you know, some institutions very important for democratic part of Europe and to be in the opposition to two totalitarian regimes, Nazism and communism. And in this slide, you have another key context identified, which was identified in freedom of expression cases. So the European Court of Human Rights said that a remark directed against the Convention's underlying values. So we have here again this key concept. For example, speech denying the reality of crimes against humanity and war crimes is removed from the protection of freedom of expression. So if something is against the underlying values of the Convention, it has strong consequences, legal consequences. In this freedom of expression context, you know, speech is excluded from the scope of the Convention protection. So please remember about these underlying values of the Convention as a key legal concept. This concept is very important for the subject of my presentation, which is focused on the question of whether there is obligation to investigate historical mass-scale crimes. If under a convention, the member states are obliged to investigate the atrocities of the past. Key provision for answering this question, for anchoring this question, is Article 2 of the European Convention of Human Rights, which protects life, the right to life. You have this provision on this slide. It's very simple also for those people who are not lawyers. Life is protected. No one shall be deprived of his life. The question, however, is the interpretation of this provision. That's a huge story, fascinating story, but I concentrate only on two issues. Under Article 2, member states have two obligations. The first one is negative. The obligation, the prohibition of not taking human life. But there is also a very important positive obligation to investigate, to conduct an effective investigation. There is nothing about this obligation, procedural obligation, in the text of Article 2, but anyway, that's something very important for the content of Article 2, and this obligation has been elaborated in the case law of the European Court of Human Rights. So the question is whether this obligation to investigate exists in the context of killings, mass-scale killings. We can say killings contrary to the underlying values of the Convention, killings which happened historically. So, for example, during the Second World War, which happened in the 50s, in the 60s, for example, in the context of civil war in Algeria. And we can identify also other historical contexts relevant for the question of this positive obligation to investigate historical atrocities, mass-scale killings, summary executions, tortures, and so on and so on. The critical date, however, is very important for the answering this question. The critical date of ratification of the Convention by a given state. Because the Convention, I can give you some more information. Okay, perhaps starting from this slide. was elaborated in 1950. It entered into force in 1953. The question is, however, if the positive obligation to investigate covers pre-convention atrocities, crimes, executions, and so on. Also, the question is, if the obligation to investigate covers events, atrocities preceding the ratification of the convention by a given state. I will concentrate on the Katyn massacre case in the European Court of Human Rights, which is the most important case answering the question of whether there is this procedural obligation to investigate. And in the Katyn case, we have these two aspects engaged. The Katyn massacre was committed in spring 1940. The Katyn massacre preceded the enactment of the convention. The Katyn massacre case, the Katyn massacre preceded the ratification of the convention by the Russian Federation, which happened on the 5th of May 1998. Here we have a brief outline of what the Katyn massacre was. It was a mass killing committed in 1940. Mass killing of almost 22,000 people in several places. The responsibility of the Soviet Union for this massacre had been denied for decades. So the Soviet Union alleged the Katyn massacre had been committed by the Germans, by the Nazis. Only in 1990 did the Russian investigation in the Katyn massacre started, and at that time still the Soviet Union recognized the Soviet responsibility for the massacre. So you have here basic information on the Russian Katyn investigation. The Katyn investigation in Russia lasted for 14 years, and it was ended in 2004 with two very disappointing decisions. The first one was to stop the investigation without revealing the results of the investigation more. As you have here on the slide, 36 volumes of the Katyn investigation file were considered to be secret, to protect the key security interests of the Russian Federation. Very incredible, I would say, in the context of what the Russian Federation pretended to be at that time. But it is, of course, illustrative of the change that happened in Russia, in the Russian Federation, under the rule of Mr. Putin. Another decision, okay, perhaps I stop at this place. So the decisions concerning the Russian investigation were revealed some months later in March 2005. So we were disappointed with the results of the Russian investigation, and we were thinking about possible avenues for finding international law possibilities to cope with this problem of the Russian Katyn investigation. So our first thoughts were about the Strasbourg court. Here, perhaps one more information. In 1994, the prosecutor in charge of the Katyn investigation, Mr. Anatoly Yablokov, proposed to close the investigation because of the death of those responsible for the crime, but to characterize he proposed to characterize legally the Katyn massacre as war crime, crime against humanity, and even genocide. Mr. Ryabokov was immediately sacked from his post and replaced by another person. But this information is also, I think, important in order to have a fuller perspective on the Katyn investigation in Russia. And now, the Strasbourg proceeding, we had to exhaust some legal proceedings in Russia. I will deal with these proceedings in my written contribution. So let's concentrate only what was the Katyn case in the Strasbourg court. Here you have the main information about how this case was dealt at the Strasbourg court. It was dealt twice. First, before a chamber composed of 7 judges, and then by the biggest Strasbourg formation, the Grand Chamber. And because I was the leading lawyer in this case, so I was personally involved in this case, we presented 3 allegations, grievances against the Russian Federation. The first one was related to the right to life, but there were 2 other allegations under Article 3, that's prohibition of maltreatment, and here we referred to the proceedings in Russia in which the Russian authorities denied actually the reality of the Katyn massacre, saying that the Polish officers disappeared in spring 1940. Their fate was known, where they had been kept in the prisoners of war camps, but suddenly they disappeared and their fate is unknown. So that was a case of denial, actually. And the question, very fascinating legally, but perhaps not so fascinating for not lawyers, but anyway, I will try to introduce you to some legal stuff, very important for our submissions to the European Court of Human Rights. So first, the question was whether Russia is obliged to investigate the Katyn massacre under the European Convention of Human Rights. And in this context, we had absolutely contradictory case law of the European Court of Human Rights. Here on this slide, you have 2 decisions concerning Romania, separated only by 2 years. In the first decision, the European Court of Human Rights unanimously said there is no obligation to investigate. When, you know, the crucial act, the triggering act of killing happened before the ratification of the convention by Romania. 2 years later, the European Court of Human Rights said unanimously again that there is procedural obligation to investigate. So we had 2 absolutely contradictory decisions of the European Court of Human Rights. Subsequently, there is a group of other cases in which the European Court of Human Rights said there was no obligation to investigate historical cases, pre-ratification cases. But as it happens in the European Court of Human Rights from time to time, the European Court of Human Rights started changing its position, saying there is procedural obligation to investigate. So you have here again 2 other cases identifying, confirming the obligation to investigate. The most important of these cases is the Schillich case, which was decided eventually by the Grand Chamber and which created the 2 tests verifying whether there is this procedural obligation to investigate. The first test was based on the proportion rule, and it can be summarized in the following way. The state is obliged to investigate pre-ratification killings if a significant proportion of the procedural steps, whatever significant proportion is. Anyway, a significant proportion of the procedural steps required by this provision will have been or ought to have been carried out after the critical date, the ratification date. So something significant happened or should have happened after the ratification date. But there is the second test, which says, however, the court does not exclude that in certain circumstances the connection could also be based on the need to ensure that the guarantees and the underlying values of the convention are protected in a real and effective way. It means that investigation is needed in order to protect the underlying values of the convention. If there is a huge scale killing, summary execution, it means that, you know, such a killing undermines the underlying values of the convention, so there is obligation to investigate such crimes. So we, in our submissions to the European Court of Human Rights, focused on this second convention values test. And what happened? The European Court of Human Rights rendered its cutting case judgment on the 16th of April of 2010, and you have here composition of the chamber. Conclusions. Violation of Article 38. Russia did not cooperate with the European Court of Human Rights because Russia did not provide the court with key documents from the cutting investigation file. Second, violation of Article 3, denigrating and inhuman treatment of the relatives of the victims. And eventually, court is not competent to hear the case under Article 2, so there is no obligation to investigate. The third, the Article 2 decision was based on the following assumptions. The first one is very promising. The Katyn massacre was a mass-scale, imprescriptible crime of international law, contrary to the underlying values of the convention. But there was something new. Additionally, there must be a new sufficiently important material surfacing in the post-ratification period. That was something new, emerging for the first time, identified for the first time in the Katyn massacre verdict. So we were not aware about this, you know, our procedural obligation to identify these new elements emerging in the post-ratification period. Conclusion, there was no obligation to investigate, was taken by the European Court of Human Rights by the narrowest majority of 4 votes to 3. And you have here those members of the chamber who voted that there was no obligation. Russia, Ukraine, Czech Republic, Slovenia. And here, 3 judges, the 3 judges who were for the obligation to investigate. Luxembourg, Liechtenstein, Germany. So, we requested the case to be reheard by the Grand Chamber of the European Court of Human Rights, and the panel of 5 judges allowed our request. So we had the proceedings before the Grand Chamber. And in these proceedings, we quoted, we referred to, you know, these new elements emerging in the post-ratification period. I am finishing in 5 minutes, so I am aware about my time. So we quoted a number of decisions important for the investigation in Russia in the context of this requirement of new facts, new evidence emerging in the post-ratification period. Okay, so perhaps 5 minutes more. Thank you very much for your generosity, Mr. Chair. So here, the conclusion of the Grand Chamber. Very disappointing for us, and this conclusion was worse than the conclusion taken by the Chamber. Unanimously, the European Court of Human Rights stated that Russia violated Article 38 because it did not cooperate with the European Court of Human Rights. Then there was no violation of Article 3. The Chamber decision was different in this aspect. So we lost on Article 3, although we were successful before the Chamber. And lastly, the court is not competent to hear the case under Article 2, in other words, to verify if the Russian Federation fulfilled its obligation to effectively investigate the Katyn massacre. The Katyn massacre was outside the temporal scope of the convention, in other words. Why? The position adopted by the Grand Chamber was different from that of the Chamber. First, referring to the genuine connection proportion rule, so these significant elements emerging in the post-ratification period, or significant number of steps undertaken in the post-ratification period. The European Court of Human Rights, as the Grand Chamber said, quotation, the duration of the time span separating the triggering act, killing, and the critical date, ratification of the convention by, in this case, Russia, must remain reasonably short and should not exceed 10 years. 10 years. My question is, why 10 years? Why not 5 years, 20 years, 12 years, 7 years? 12 and 7 are also very important numbers. My answer is, perhaps it is because 10 is the first two-digit number. Of course, I'm kidding. I'm kidding. But you know, it's something absolutely surprising. It's without any justification. But, as I said, we referred to the underlying values of the convention. So to this second test, elaborated in the Schillich versus Slovenia case. But, again, very surprisingly, the European Court of Human Rights answered, quotation, the key quotation you have on this slide, the underlying convention values test means that the triggering event, so the killing, is of a larger dimension than an ordinary criminal offense and amounts to the negation of the very foundation of the convention, such as war crimes, crimes against humanity, or genocide. The Katyn massacre was a war crime and in its civil part also a crime against humanity. But the European Court of Human Rights said, and you have this at the end of this quotation, but the convention values clause cannot be applied to events that occurred prior to November 4th, 1950. It is the adoption of the convention. So the obligation to investigate based on the protection on the underlying values of the convention does not reach as far as before the enactment of the convention. These thesis, this conclusion is, again, very surprising. Some judges disagreed with the position adopted by the court. So here you have some parts, quotations from their dissenting opinion appended to the judgment. And I perhaps quote only two fragments of this dissent. The court has missed an opportunity to uphold the Convention Values Clause in the Schilling Principles. In doing so, it has deprived that clause of its humanitarian effect in the case at hand and potentially weakened its effects in the event of its future application. This approach is untenable if the convention system is to fulfill the role for which it was intended, to provide a court that would act as a conscience of Europe. And the second fragment. We regret the majority's interpretation of the humanitarian clause in the most non-humanitarian way. We express our profound disagreement and dissatisfaction with the findings of the majority in this case, a case of most hideous human rights violation, which turn the applicant's long history of justice delayed into a permanent case of justice denied. I am very familiar with judgments of the European Court of Human Rights, with also dissents appended to judgments of the European Court of Human Rights, and this one is one of the strongest. Reactions. There was huge criticism following the Katyn massacre verdict of the Grand Chamber, and on this slide you have a quotation from Professor William Schabas, a very renowned expert in international humanitarian law, international law, and human rights law. He wrote, quotation, "The Grand Chamber decision to propose for November 1950 as the beginning of the convention underlying values is the human rights equivalent of religious fundamentalists who argue that the world began 6,000 years ago." Very figurative criticism, but very, very justified, I think. And to go to conclusions. The Katyn massacre case was very important, was the key case in the Strasbourg court for elaborating the standards related to the obligation to investigate historical atrocities, historical killings, historical mass-scale executions, and so on and so on. It closed the gates for eligible potential applicants because there were some reasons for that. I will leave this matter, this issue for discussion, but I will conclude with some other historical cases from the European Court of Human Rights. On this slide, the last one, you have such cases. There is a group of Cyprus cases. So cases generally against Turkey, but there are also cases against Greece. Cases related to the Turkish intervention in 1974 on the island. Many people disappeared, and their fate is still unknown. The European Court of Human Rights considered such cases not as killings, but as disappearance cases. And you know, this distinction between killings and disappearance made the court competent to deal with such cases and to investigate whether there was an efficient investigation for this group of cases. So these Cyprus cases were considered admissible because they were about disappearance, not about killings. So please remember about the distinction between the position adopted by the Strasbourg court for killing cases and disappearance cases. There was a huge group of cases related to the Spanish Civil War, so years 1936-39. In these cases, the European Court of Human Rights considered applications inadmissible because there was no new elements emerging, significant elements emerging after the ratification by Spain of the European Convention of Human Rights. And there is also a very important, very interesting case against the European Kingdom. A case about a killing of a group of peasants in Malaya in 1948. That's the Chao case. The case was decided after the Grand Chamber verdict judgment in the Katyn case, and as the massacre had taken place in 1948, the European Court of Human Rights decided that both tests, the test of 10 years and the test of underlying values of the convention, did not apply to these proceedings, to this case. So the case was dismissed and as inadmissible. My time has finished, so thank you very much for your attention. I am open to answer any of your questions in the discussion period. Thank you very much.
Thank you very much for this very interesting and insightful presentation with lots of information that only the ones could share with us who really looked into the case also from the inside. So thank you so much. We are moving on. We will collect the questions at the very end of this session. So without undue delay, let me introduce our next speaker, Dr. Filip Cionczyk, who represents the University of Social Sciences and Humanities in Warsaw, but he's also very active internationally. He's also, as I realized, active in the Baltic countries as myself, but in Latvia, in case of our speaker, the very reputable Riga Graduate School of Law. Before he earned his PhD from the University of Warsaw, he specializes in sociology of law and history of law. He also is a graduate of International Institute for the Sociology of Law, ONIATI in Spain. And the title of the presentation, a very interesting one, Constitutionalized by the Past, Central European Approach to Political Communities Recreation, Experience, Influence, Prospects for the Future. Dr. Cionczyk, the floor is yours.
Thank you very much, Professor Radwan. It's a great pleasure to be here. And first of all, I'd like to thank Professor Kamiński for the very interesting presentation, because it really shows that we, the lawyers, we have some problem with the approach to the past and how we can locate the past in our legal reasoning. And this presentation, Constitutionalized by the Past, it's like a brief presentation of my recent experience and this, how I see the future of the social legal studies on collective memories and the legal influence on collective memories from the Central European perspective. So we go from Strasbourg, we take a plane or the train, and now we go to the Central Europe. And what I would like to share, and honestly speaking, and I have to confess, it's some kind of dealing with my young scholar arrogance when I started my PhD, and I thought from the Central European perspective that everything is pretty obvious. When I went to ONIATI for the master program, I noticed that and I met people from different backgrounds, mainly Basque, but also from Latin American or African. I noticed that the things which are totally obvious for us, they are clear, so we shouldn't interpret them like we say in legal reasoning. They are much more complicated. So the bullet points of my speech are mostly based on three elements: the experience of Central Europe, the legitimacy, the element of legitimacy, post-communist legitimacy of new political communities, and communities recreation. The second part is the influence of the memory legislation and the universal character of the memory legislation in Central Europe, but not at the level of the statute on concrete institutions or institutionalization. I would like to focus on the element of self-obligation, taking into account the theory of the constitutionality. So the element of the constitutionalization rooted in past in Central Europe. So the question is it the regional, global, or are there any points of reference? Maybe it's something maybe it's something what comes from our intuition. And here I would like to take an example, and I will briefly analyze the very up-to-date topic in Spain at the moment, because Spain is proceeding the memory on democratic law. Just yesterday it returned to the parliament, and I would like to share some elements. So the prospects for the future are mostly connected with the global trends of constitutionalizing the political communities and rooting the reasons and the legitimacy in the past. So, and this is an element of my arrogance. When I was a student, I thought that for us, the Central Europe and the Central Europeans, we know everything, and our perspective on some identity elements are clear, obvious, and they are out of discussion. But what came to my mind was the first moment when I started to have some doubts was when I read Neil McCormick and his book about the nationalism and the liberal democracy in Case Study of Scotland. Of course, the Neil McCormick personal background probably was stimulating. His father was a founder of Scottish National Party. But still, I started to look for some elements or points of reference which defined us during the transition as a Central Europeans different from the Soviets. So first of all, we wanted from some social history perspective to locate ourselves different from Soviets. And I found this, the kidnapped West, the famous Milan's Kundera essay. That said that we can no longer consider what took place in Prague or Warsaw and in its essence as a drama of Eastern Europe, of the Soviet bloc of communists. It is a drama of the West. A West that kidnapped, displaced, and brainwashed, nevertheless insists on defending its identity. It's a mid-80s, so just the beginning of even perestroika processes. But Kundera for me, and I would like, and my intention for the future research is to take this quotation as a starting point for asking the variables for maybe defining some elements of identity important for constitutionalization. And what about the constitutionalization? The Czech-British scholar Jiří Příban, following Niklas Luhmann, in one of his books, The Legal Symbolism, he took the quotation very fundamental for my future further arguments, so that the moral self-obligation of the political communities is located in constitutional preambles, where they disclose the ideas and the fundamental values, but the moral, mythical foundations of the political community, and the role of the constitutional preamble. And now, as a lawyer, I want to say, I want to be out of the discussion about the normativity or lack of the normativity of the preamble, because sometimes between lawyers there is some discussion, and it's not an issue for me at the moment. It's rather like a creation of some symbolic framework of identity and for identity. And now some rephrasing of very known "In West We Trust." So the extended Central Europe, what the Central Europe is. Let's return to Kundera once again. We say that we are the West kidnapped to East by the Yalta decision, by Soviets, by some other factors. So by reconstructing Kundera, what is the Central Europe and who the Central Europeans are? The Western Christianity experience. This is the point one. The Central Europeans, Europe means West for us. And it's sometimes in a public discourse or in pop culture, for Poles and other Central Europeans, sometimes it's transferred in a very different manner, including even some comedies on pop culture. But Kundera used an example of he tried to define why the Central Europeans are different from East. It's a community of equal nations treating the others with the mutual respect. So not like a Russian vision of the region of some form of domination, of some form of strong or weaker influence. So something what we call by Ruski mir defined in Russian. And historical belonging to the West because of the culture. But why the Central Europe is extended? When I read his essay, I have a feeling that it is just limited into the satellite states. But probably we all know that the Baltics are the good and pretty obvious argument that they also want to belong. Once, of course, in a okay, something has happened, and the different collective vision of community. The community, something has happened with my slide. Sorry. But why the Central Europe is extended? We have some countries which always historically belonged to the East, but they try to follow same ideas, or they try to share these values to justify their accession to the Western world. Identify institutionally with the Western structures. So when they recreate their political communities, when they are adopting the Constitution, when they try to transfer this moral mythical foundation of the political community, by using the past narratives, they try to somehow justify their belonging to the West. And as in Estonia, I made this table, and I wanted to show you this tension, or this element of coexisting, the references to the past and the national heritage in several constitutions and the preambles, and the references to the so-called Western values. So the Western values are mainly the human rights, the individual rights, freedoms, and so the general catalog of something what was understood by Central Europeans under the communism as a Western values, or today's the universality of some liberal democratic values. So it exists in Estonia. The Latvia, it is a very interesting case. Why I use two days? It's 1990 and 2014. 1990 is a very important year for Latvians because it's adoption of Act of Latvian State Reestablishment. So, in fact, the Declaration of Re-Independence edited by today's president of Latvia, Eglītis Levits. Another lawyer who was very active was quoted by Professor Ineta Ziemele. It was like a bunch of youngsters who had a contact with the Western academia, and they've been very influential at that time. And there was a big tension between Latvian youngsters and the old Soviet academia, represented by boyars, about the character of Latvia state. So the decision about the state continuity, adopting of state continuity doctrine was mainly forced by Levits and the other young scholars. But in 1990, they adopted the Act of the State Recreation, and they used the memory narratives to justify the recreation of the state. There were arguments about the events of 1940, the forged elections under the Soviet occupation, the element of the references to the national Latvian identity, but also they said, okay, so if the election was forged, the Latvia exists legally. So now our obligation as a supreme Soviet is to recreate the state and to restitute it de facto. So they use the memory narratives for, in fact, the political game, but for the recreation of independent Latvia and the political community. And the Declaration of Independence was very Latvian in terms of, if we know the social structure of the Baltic states, mainly Latvia and Estonia, probably you all know what I mean. But 2014, it's a moment when Latvians are adopting the amendment to the constitution and they are adding the preamble. They are adding the preamble containing the very national narratives after very concrete event, the language referendum, when some representatives of Russian minority have used the very special path. I have no time to explain it, but there are two types of proceeding under the popular initiative in Latvia. And one of them ends up by mandatory referendum if the act is rejected by the parliament. So some representatives of Russian speakers used this second path and they forced Latvian to have a mandatory referendum on the Russian as a second official language of Latvia. So they lost this referendum considerably. It was like 79 to 21 or something like this, but they lost. After the referendum, the period between 2012 and 2014, it is a moment when Latvians are preparing and adopting the preamble which clearly underlines that the Latvia is a Latvian state of the Latvian people. Lithuania, same. The memory narratives appears in the act of the recreation in the one sentences of Lithuanian state, but they are also very present in the preamble. Poland, Hungary, since in Orban constitution it's overbuilt, and there are many narratives explaining the very special character of Hungary. And now why the Central Europe is extended? Because at the beginning of 21st century, we clearly noticed that Ukraine politically wants to integrate themselves with the West. And also, they try to build now the nation state, but also they try to make references to the values. And the question is about the Georgia. First of all, if we use this element, the elements of Kundera arguments about the Western Christianity, of course, Georgia is not belonging to the Western Christianity. Ukraine also is not belonging to the Western Christianity, but they try to balance it somehow. But there is no, for example, the reference to the past and the national heritage in Georgian constitution. But we know that politically they choose the way to be a part of European community. So what does it mean constitutionalized by the past? First of all, it's an element of this political community legitimacy. The Polish scholar Anna Młynarska-Sobaczewska in her papers usually makes these arguments that using the memory narratives is to show the historical legitimacy to be the power holder at the moment. In case of Slovakia, it's somehow interesting because they also have direct references to the past in their constitution preamble, but they don't create the links into the constitution, into the Czechoslovak heritage, for example, but they look for the roots of their state in Great Moravian state. So the first Slavic state from 9th century. Okay, so what are the prospects for the future? The first element, and I noticed that in the last 5 years when I've been writing my PhD about the institutionalization of the collective memories by law, was this tension between the national character of the political communities in Central Europe, which is quite clearly underlined in several acts constituting the political communities after the communists. So I mean all these countries plus Slovakia. There was also some change in Romania in 2003. It is pretty interesting. They decided to adopt the amendment to the constitution. They have no preamble, but they decided to change the normative part of the constitution, the Article 1.3 of Romanian constitution, which determines the character of the state. So Romania is a democratic state under the rule of law and so on and so on and so on, but in the spirit of democratic tradition of Romanian people and the ideas of the revolution of December 1989. So what does it mean if we look sociologically or from political sense? What does it mean, the ideas of the revolution of December 1989, if we know the history of Romanian revolution and there's some political backgrounds? Okay, so the redefinition. There is, at the moment, there is the tension or political tension, and unfortunately this discussion, mainly with elements of identity, became very political. I will say it a bit later. I'm coming to, of course, I'm coming to my final points in 2 minutes. And what kinds of the memory narratives play? In Central Europe, as I said at the beginning, I thought that it was pretty obvious for us that they played a role to, following Professor Młynarska-Sobaczewska, to legitimize the political community. But now we have this Spanish case and the influence. So in Spanish case, I published a couple of weeks ago an article about the draft law on the memory, on the democratic memory in Spain, and it's pretty obvious that the socialist and Podemos government tries to reject the pact. So if we say that the Spain was rooted deeply in the pact, they try to reject the pact by the memory law. In the reasoning justifying the submission of the draft law, they even say that, okay, the memory politics is nothing strange for the Spanish people. Please remember that the Spanish transition was rooted in this collective forgetting and collective forgiving. But they say, it is nothing strange that we use the memory narratives and we introduce the memory politics, because Spanish society under the Franco period was a subject of the very strong memory policies, so it's nothing strange for them. We can introduce another memory politics. But they make a reference to the different values. They mostly want to root the reconstruction of the Spanish political community in the human rights, in the Western values, in the liberal values, in some kind of Western universalism, but not in national character. But from the other side, the autonomous communities are adopting their own memories laws, and Basques, Catalanians, Valencianas, they are doing this, and they're doing the reference to the past. So what's the problem at the moment with the studies on the communities constitutionalized by the past? It's a political approach. And when I read Lech Morawski's piece in his last journal, it was Law and the Social Bounds, there was an article about the constitutional identity of Poles. And he used such an argument. Okay, our national identity is out of the discussion, but we don't have constitutional identity. But from the other side, for the liberal circumstances, the term of constitutional identity, or using the creation of constitutional identity rooted in some kind of national identity, which has to be maintained because it's some kind of moral obligation written in a legal text, at least in a theory, they identify that with some kind of politics of nationalism. And there is some counter article written by Laurent Pech from Middlesex University of London and Dmitry Kochenov at the moment in the CEU, as far as I know, why autocrats need constitutional identity. So this issue is always somehow affected by the political speech and the political discourse. And of course, and the question is it natural or not? So do we have any elements of influence? Are we influencing each other in terms of using the memory, using this constitutionalizing our communities by using the past narratives? Honestly speaking, I don't know. Sometimes I had the feeling when I took the declaration of the independence of State of the Israel. We, the Central Europeans, we love to say that they were mostly affected by the place of their origins, the movement, the Zionist movement by Poland, by other Central Europeans, and maybe they took it from Central Europe. But of course, the declaration is a part of this constitutional catalog of the State of the Israel. And it's first of all, it's very ideological in terms of the Zionist ideology and the Zionist idea. There are even the references to the Holocaust when they say that, of course, those Jews who were not following the Zionists, maybe if you follow the Zionists in the mid-war period, maybe the Holocaust shouldn't touch us so considerably as it happened. So there are even some references between the Holocaust and the lack of understanding of the Zionist movement in the mid-war period in this declaration. This is, let's say, my final point. So the element, of course, the constitutionalization in the past is a fact in Central Europe. The Central European identity, it is a very interesting issue for the research as another, and Mark Rosenfeld, he made the classification of constitutional identities where he has 7 identities. Transitional one, and the most important for us is transitional one and the post-colonial. So the transitional one, for him, is a Spanish constitutional identity, but they're trying to reject this identity because for him, transitional one means rooted in forgetting and forgiving. So if Spain at the moment is trying to recreate the community, Rosenfeld's categories are quite problematic. The another one is a post-colonial. With the Central Europeans, taking his variables, we don't belong to any of these categories, so maybe it's a place for the studies on 8 constitutional identity. Thank you very much.
Thank you very much, Professor Radwan, for the invitation, for the possibility to present a paper here at this very interesting conference, and for the kind introduction. It's the faith of the last speaker in the panel that the time already ran out before starting speaking, but I hope you are generous with me as well. The focus of my presentation lays on the judicial punishment and memory as one of the milestones of transitional justice. In the first month after liberation in 1945, the rapid punishment of perpetrators who committed serious crimes was a widely discussed topic in Austria. Numerous articles in the newspapers reported offenses, especially those at the end of the Nazi regime, such as the crimes committed against Jewish Hungarian forced laborers building the southeast wall, and in the course of the death marches to the Mauthausen concentration camp. The provisional cabinet the Austrian government accepted by the Soviet occupying forces until the recognition by the Western allies put the punishment of Nazi crimes on the top of the agenda. Justice State Secretary and later Minister of Justice Josef Gehre announced that Nazi crimes would be punished by the rule of law. Quote, "At the moment that we are free, we have to demonstrate to the public that we do not want to wait until the outside world judges us on the basis of the laws of war. We want to show that we want to set our own house in order. We do not want to exercise revenge, and therefore the process should be imbued with all the guarantees of legal certainty. Not lastly, we are responsible to the thousands of victims who suffered unthinkable torture, who were murdered and who languished in the concentration camps." Quote end. On 8th of May 1945, a few hours before the surrender of the Wehrmacht, the provisional government passed the so-called Prohibition Act, Verbotsgesetz, That means the prohibition of the Nazi Party and its branches, as well as the banning of Nazi activities in the future. On 26 June 1945, the war criminal law, Kriegsverbrechergesetz, was passed and punished the following offenses: war crimes, torture and abuse in concentration camps, violations of human rights and human dignity, murder and manslaughter, both in concentration camps as well as in conjunction with Nazi euthanasia activities, crimes committed at the end of the Nazi regime, deportations, unjust enrichment, the so-called Aryanization, as well as denunciation. Special courts, the so-called people's courts, were established in Vienna, Linz, Graz, and Innsbruck, and worked in senates of 2 professional judges and 3 lay assessors. At the first glance, the statistics show impressive results for the people's courts that operated from 1945 to 1955. All in all, the public prosecutors brought 136,829 cases to court. Indictments were issued in 148 cases, of which 23,477 cases received verdicts, out of them 9,870 acquittals and 13,607 verdicts of guilty. 43 accused were sentenced to death, 29 to life imprisonment. 30 of the death sentences were executed, 2 of the condemned committed suicide. Almost 80% of the investigations were initiated until 1948. After that, judicial investigations of Nazi crimes declined dramatically. These impressive numbers, however, have to be put into perspective to the fact that the majority of the accused were charged for membership in the Nazi Party before 1938, for the assumption of certain functions within the Nazi Party, or for false claims regarding party membership. Only a number of about 500 persons were charged with committing violent crimes. The period of the Austrian People's Courts was nevertheless the most intense judicial coming to terms with Nazi crimes in Austrian post-war history. The abolition of the People's Courts in December 1955, together with the Nazi amnesty in 1957, signifies the end of a thorough judicial engagement in punishing Nazi crimes. The People's Courts reflected that the widespread guilt of Austrian men and women in the Nazi system. The great number of male and female perpetrators, from little denouncers to sadistic murders, identify how many people were connected to crimes committed by the Nazis. Such a large number of criminals left no one unaware. The trials provide impressive evidence of how many people were involved into Nazi crimes. In the transitional phase, from Nazi dictatorship to a democratic constitutional state, 2 different political concepts faced each other. One concept was the so-called victims doctrine. That means Austria as a whole was the first victim of Nazi Germany. For avoidance of misunderstanding, that didn't refer, for instance, to the Holocaust victims. The other concept based on the Allied call to the Austrian people to put up resistance against the Nazi regime, as the corresponsibility clause of the Moscow Declaration in November 1943 urged. The widespread myth in society and politics over decades that Austria as a whole was the victim of Nazism left little space for remembrance of actual victims of the Nazi terror regime. On the other hand, the resistance of Austrian men and women referring to the Moscow Declaration was emphasized. The function of linking the concepts mentioned before was to achieve the major goal of a state treaty to guarantee the independence of Austria. The highlighting of resistance as an instrument to establish the national foundation myth is reflected by the focus of all political groups regarding the Austrian freedom struggle, which was manifested in numerous commemoration signs at that time. But at the end of the 1940s, commemorating the resistance against the Nazi regime was in the following decade, step by step, overlapped by other very effective narratives disseminated by the returning prisoners of war and former soldiers of the Wehrmacht. Reports of their experiences and their suffering on the battlefields suppressed the suffering of the actual victims of the Nazi regime, such as the Jews and other groups of victims. Remembrance of the fallen soldiers of the Second World War became the predominant memory culture in Austria. In almost every Austrian community, a war memorial was erected, or the memorials of the First World War were expanded. The soldiers were celebrated as heroes and heroes of duty fulfillment and bravery. At that time, anti-fascist consensus of the first years after liberation broke down. Memorizing the resistance was then only perceived by the victims' associations, the Communist Party, and proponents of the Social Democratic Party, especially the member of the National Council, Rosa Jochmann, and the trade union representative, Josef Hindels, are to be emphasized in this context. From the middle of the 1960s on, the political climate changed and the partial, slow transformation of historical awareness can be stated. The first memory signs for the victims of the Holocaust were set, limited, however, to regional initiatives. Besides that, again, a stronger emphasis on resistant fighters is notable. A memorial to the Austrian freedom struggle was erected along the outside wall of the Vienna Hofburg. A scholarly debate about the Nazi past got started in the 1960s. In 1963, the Documentation Center of Austrian Resistance was founded, as well as institutes for contemporary history settled at the University of Vienna and Linz. The participation of Austrian perpetrators in the Nazi crimes, however, was still unreflected. It was Simon Wiesenthal who played an important role in researching Nazi perpetrators. His activities, as well as important trials in Germany and Israel, that means the Auschwitz trials in Frankfurt and the Eichmann trial in Jerusalem, put pressure on Austrian justice to initiate proceedings as well. This led in the late 1960s and early 1970s to a series of scandalous verdicts and misjudgments, and damaged the reputation of Austrian justice in terms of punishing Nazi crimes. Let me give you a few examples for that. The designers of the Auschwitz gas chambers, Walter de Jacco and Fritz Ertl, as well as two members of the SS guards at Auschwitz-Birkenau, Otto Graf and Franz Wunsch, were put on trial in Vienna, but all of them were acquitted. This represented the only 4 verdicts in Austria dealing with the mass murders in Auschwitz after the abolition of the People's Courts in 1955. No legally binding verdict was issued against Franz Murer. He was administrator of the Vilna ghetto and thereby responsible for the malnutrition of the Jews there. The trial against Ernst Lerch, adjutant to Odilo Globocnik during the mass murder in the course of Aktion Reinhardt, was abandoned after 2 days and finally closed. The 4 main trials against Eichmann's co-worker Franz Nowak, who organized the transports of Austrian Jews to the death camps, aroused a broader public interest. The verdicts against the so-called dispatcher of death were altogether 3 times invalidated by the Supreme Court on the basis of an apparent jury's legal error. In April 1972, a jury rendered a guilty verdict but recognized the statute of limitation and sentenced Nowak only to 7 years in prison. From 1955 to the present, only 35 trials for Nazi crimes took place in Austria. 26 of them were for murders of Jews. A total of only 49 more people were charged, of whom 20 were found guilty and 23 acquitted. In 5 cases, the trials were suspended without the final verdict. On the 20 charged guilty, 5 were for mass murder of Jews in eastern Galicia, today Ukraine. 4 participated in murder of Poles and Jews in central Poland. Prosecutors and courts launched trials against more than 60 former SS guards in Auschwitz-Birkenau, against more than 50 male and female guards of the Lublin Majdanek concentration and extermination camp, as well as against more than 100 members of police battalions who participated in the murder of Jewish and non-Jewish people in eastern Galicia. The majority of these examinations were dismissed prior to indictment. Only 7 accused were brought to trial, and not a single one was found guilty. Only 3 lifelong verdicts were issued. Against Leopold Mitas, he was charged with participation in mass murder of Polish Jews in Borislav. Against Josef Gabriel, he was charged with participation in the mass murder of Jews in eastern Galicia. And against Stefan Rojko, he was charged with murder and abuse of Polish prisoners and Jews in the Kleine Festung, the little fortress in Theresienstadt. The last verdict for Nazi crimes, for violent Nazi crimes, was passed in December 1975. The accused was the former SS Unterscharführer and guard at the Mauthausen concentration camp and its subcamp Ebensee, Johann Vinzenz Gogel. As in his first trial at the regional court in Linz, the jury at the regional court in Vienna acquitted him despite incriminating evidence of all charges. This acquittal was the very last verdict concerning Nazi crimes passed in Austria. In the mid-1980s, the so-called Waldheim debate, in connection with the election campaign for federal president in 1986 of the previous UN General Secretary Kurt Waldheim, nominated by the Conservative Party, caused a final break with the historical narrative valid until then and allowed a changed view of the Nazi past in Austria. For the first time, Austrians undertook a more comprehensive consideration of the victims of Nazi crimes, who until then had been denied acknowledgement, especially the Jews, but also Sinti and Roma, the victims of euthanasia and homosexuals. As examples are the memorial against war and fascism by the sculptor Alfred Rütliczka on the Albertinerplatz in Vienna, and the Holocaust memorial by the British artist Rachel Whiteread at the Judenplatz in Vienna can be mentioned. Both of them demonstrate that the Holocaust has moved into a certain central position in official memory culture, but nevertheless triggered a public heated debate. From the late 1980s on, several high-ranking Austrian politicians, Kurt Waldheim himself, Federal Chancellor Franz Vranitzky, and Federal President Thomas Klestil, admitted the first time that Austrians were not only victims of the Nazi regime, but to a not inconsiderable number perpetrators as well. From the 1990s on, the necessity and importance of commemoration of the victims and naming of the perpetrators is consensus to a broader public. But this did not lead to a return to judicial punishment of Nazi crimes. The main trial against the euthanasia Dr. Heinrich Gross was suspended in 2000 and ended with his death in 2005. The trial against the former guard at the Majdanek concentration camp, Erna Wallisch, had to be suspended in 2008, as well as the preliminary investigation of concentration camp guard Johann Hummel in 2015. On the other hand, interesting in scientific research on both topics, memory culture, as well as trials against Nazi perpetrators, has grown over the past 2 decades. Not least the Austrian Research Agency for Post-War Justice, of which I am the director together with Dr. Gasse, who will speak to us in a few minutes, has presented substantial research on this topic. So let me come to a conclusion. In the years from 2000 on, the Austrian National Assembly has decided to compensate displaced Jews and forced laborers, as well as the restitution of confiscated Jewish property, and has set up a commission of historians as well as the National Fund for this purpose. In addition to the Jews, other groups of victims, such as the Sinti and Roma, or the homosexuals, were recognized. In the last decades, the culture of remembrance has arrived in the middle of civil society, as can be seen in numerous private and regional commemoration initiatives. But official Austria also sets standards in various ways, be in the form of monuments or memorial days and festivals. The unveiling of the Shoah Wall of Names in Vienna a few days ago is the latest example of this. However, there are still controversial debates, such as the discussion about the deserters' memorial at the Ballhausplatz in Vienna shows. Scientific research projects are dealing with a variety of topics concerning the Nazi time. Nonetheless, uncritical complacency is not the order of the day. The former scientific director of the Austrian Resistance Archive, Wolfgang Neugebauer, warned that the political education provided in the last decades apparently only reached a part of the Austrian population and did not lead to the containment of xenophobic, racist, and right-wing extremist tendencies. This assessment still applies to the present and to an even greater extent. Thank you for your attention.
Thank you so much. May I now invite all the speakers to join me here in front of the audience for the discussion round before we go for a break. So thank you so much again to our 3 speakers, and I would like to invite the audience to ask questions. Also the speakers might exchange questions and comments. So I open the round.
Okay, so maybe I will have the first question actually to Professor Kamiński. I want to play a little as a devil's advocate and ask about your personal stance about the limitations that actually should maybe be imposed to the European Court of Human Rights, because you presented the discussion about this time census regarding the rulings of the court. But for some cases, there is a reason why that applies. So what do you believe is the right way to approach this situation? What do you believe is the right way to limit the jurisprudence of the European Court? And what is maybe the wrong way?
Thank you for this question. That's a huge question, many aspectual. Of course, there is a question of how far the European Court of Human Rights should be active, should develop its jurisprudence for many years following the fall of the communist system. The European Court of Human Rights was very eager to elaborate new standards and to discover in the convention new obligations, new aspects of traditional conventional rights. So that's a bigger question, but currently the European Court of Human Rights is rather limited. Is limited by the member states exactly, because perhaps you know that since September the 1st, the new protocol to the European Convention on Human Rights entered into force, introducing the 2 pro-state principles to the convention. Exactly, that's the principle of subsidiarity. So it's something that gives the member states prerogatives. First of all, prerogatives to implement human rights. And the second principle added to the preamble is the principle of the margin of appreciations, meaning that there is no one way of executing human rights and freedoms. But apart from this very broad perspective, I would say that the Chao case is very important because it is highly demonstrative of some different perspective involved. I was talking about law. We had very good arguments starting from the imprescriptibility of some crimes as war crimes, genocide, crimes against humanity, which is a very shared international legal standard. But anyway, we still had, and I especially had, in the back of my head, the following, reflection. Perhaps the European Court of Human Rights might be afraid of opening by the cutting verdict the floodgates for other cases. There are many cases, there are many situations, there are many killings, there are many summary executions which were not dealt by law, so the perpetrators were freed. And for example, the chapter of the the Algerian chapter with huge scale executions, summary killings, mass tortures, being part of a French policy, were not dealt legally. We can identify other cases. So, for example, killings of Sudetendeutschen, Germans from Sudeten, Germans from other countries killed in the end of the Second World War and after the Second World War as well. We can point to, for example, killings committed by the British forces in Kenya and Malaya and other cases. So, perhaps the European Court of Human Rights was very unhappy about the cutting case opening, huge or generating huge potential for other cases. So as I said, I had in the back of my head, this reflection. So in our submissions to the court, we insisted, and I personally, as the person responsible for writing the final submissions, insisted that the cutting case was exceptional. It was a state orchestrated mass-scale violation of human rights. It was not an incidental, accidental killing of a prisoner of war by a group of soldiers. It was different. So we referred, for example, to the concept of the special responsibility for states for states' crimes, elaborated in the doctrine of international law in Latin America. So we provided the court, the European Court of Human Rights, with good arguments, I think, for differentiating the Katyn massacre crime case as a specific state orchestrated crime from other, imprescriptible as well, crimes such as war crimes, first of all, war crimes. But anyway, as you saw, the European Court of Human Rights was not willing to decide the cutting case for the applicants. That's a sad story, but anyway, that's also a lesson for me personally of political and legal realism. Thank you.
Just two questions. The first one to Professor Kamil.
May I ask everyone who asks questions to introduce briefly him or
I'm
herself?
Boerhaavegasse from the Vienna Wiesenthal Institute. Professor Kaminski, what would be the key, you sometimes talked about the key element which makes a case admissible or non-admissible. Who defines this key element? What is it? And the second question goes to you, is I'm just thinking about the Austrian Constitution, which doesn't refer in any way to the past, maybe because there was no any past, I don't know, it's interesting. The second one which came to my mind is the German Constitution, which is a kind of abolishing the past or whatever. It's kind of a clear break, and it's no discussion about that. And how does this fit into your argument, these two constitutions? And the third one would be the Hungarian Constitution, which is the third one would be the Hungarian Constitution, which refers to a past which is a very special past because it kind of denies another past of the Hungarian tradition, the liberal one, the 1848 tradition, and it only refers, I would say it's kind of an imposed past by the Orban government on the Hungarian society because another half would see a different, constitutionalizing a different past. And how would it fit in your argument about constitutionalizing the past?
May I have a question to our Austrian colleague?
Before, do you want to address the question that was just raised before?
I may, if you prefer.
Yeah, just go ahead.
But I also would like to have a question to our Austrian colleague. But first,
I think if you could just briefly address the question that was asked.
Okay, the answer is very simple. That's the master of the game. That's the European Court of Human Rights who decides the standards, who decides how to, interpret the particular cases. I stress the distinction that exists in the case law of the European Court of Human Rights, the distinction between killing cases and disappearance cases. If the European Court of Human Rights consider a certain case to be a disappearance case, it says the possibility of legal action at Strasbourg is open, is possible. But if it considers that's a particular case is a killing case, the answer is in the negative. The case is inadmissible. So it's up for the court, for the European Court of Human Rights to interpret, to give a special qualification. The Cyprus cases I mentioned were considered to be admissible, and the European Court of Human Rights decided for the applicants. But that was also possible to qualify such cases as, death cases, cases of, settled killings, because there were no, information about certain people for decades. So the European Court of Human Rights might have said that's a, killing case as well. Also, I mentioned in my presentation that the Russian authorities, in their reactions, especially in two sets of legal proceedings we started in Russia before going to Strasbourg, said openly the fate of Polish officers, soldiers, policemen, and other people is unknown. They had disappeared. You know, we also had, I think, some arguments to present, and we did it actually, the Katyn massacre case as a disappearance case. But anyway, the European Court of Human Rights said, okay, the Russian authorities denied, you know, the crucial facts established during the exhumations and so on and so on. But anyway, you know, the Katyn massacre happened 70 years ago. It means that, you know, the people, the soldiers involved, if I may use this word, in the events, should be considered killed. So that's a death case, that's a killing case, not disappearance case. But, you know, the final standard as elaborated by the European Court of Human Rights is in the Grand Chamber judgment in the Katyn case. It means that, you know, two tests apply to historical cases. The rule of 10 years and the rule of underlying convention values. The second test does not apply to events happening before the enactment of the convention, so before November 4, 1950. So for these reasons, the Chao case I mentioned against the UK was dismissed as inadmissible because the killing occurred in 1998 first. So the underlying values, convention values test does not apply to this situation. But secondly, the date of convention enactment, November 1950, and the UK's decision to accept the jurisdiction of the European Court of Human Rights are separated by 18 years. It means that, you know, the rule of 10 years does not apply either. But, okay, last sentence. I am waiting for a good Algerian case against France. I am waiting for a good Algerian case against France because such, you know, such a case is rooted in the post-enactment period. So the Algerian War is the end of the 50s. It means that, you know, the underlying values convention test would apply to such a case. I'm waiting for such a case.
We will proceed in the following order. Now, Dr. Sionczyk will have a chance to answer his question because he didn't have a chance. And then we have a question from the audience, yes?
Okay, thank you very much for your question. First of all, my name is Philip, so no worries if you have a problem to pronounce my surname, you can call me Philip, okay? I know it's even quite problematic for Poles. It's a strange mixture of Polish and Belarusian grammar, but still, regarding your question, you asked me about Austrian, German, and Hungarian, and there are three different approaches. I wasn't familiar with Austrian Constitution until your question, sorry for my ignorance, but thanks to Google, I can say, okay, and it works with somehow with my thesis, so, and with my argument that using memory narratives in the period of constitutionalization is autonomous decision of every political community. Example of Austria, I don't know Austrian political history sufficiently. I know like every Central European, so the Austrian Republic, the German Austrian Republic, then the Republic limited to today's Austria, yes, and the accession of Burgenland. That's the end of my knowledge about the Austrian political history. But my answer about the Germany, it's another example because they made a reference to the past, but not indirectly. They want to serve humankind and the peace in new political communities. So the experience of the past of the Third Reich forced Germany to adopt totally different, 180 degrees different political values into today's constitution. But the Central European paradox, and the Hungary is the perfect example. I love it, because usually we talk in this paradox about the tension, and the liberal circumstances speaks about the tension between the values of constitutional liberal democracy and the national memory narratives. But Hungary, the question is it the liberal state or illiberal? The exclusion of the memory narratives and the husking of the memory narratives necessary for our community is also common for the liberal communities. Latvia, the example I said, it's a Latvian state of the Latvian nation. Even if during the independence referendum, they've been producing the documents in two languages, in Russian and in Latvian. Then after the re-independence, the Russian has disappeared from the public space. So even the liberal Russians said that you cheated us. But the other way is that example of Hungary. So in Poland, we are making references in our preamble to the best tradition of the Polish First and the Second Republic, but nothing about another statehood. Of course, was it the fully independent statehood, or it was somehow artificial occupied the status of the Polish People's Republic? But the references in Polish constitution, today's Polish constitution, are made only into the 2 out of 3 previous statehoods. So this is the question, and the selective element, in terms of the legal memory policies, the lawyers follows the idea of the memory policies. So we are just asking from the past what we need, and we create the narratives. And the Hungary, it's a great example, yes, but there is another problem. Some Hungarians say that their preamble is normative. Okay, the Hungarian Constitution of 1949 was amended at the beginning of 90s. They said that this constitution is amended and it's like a temporary constitution until the nation of Hungary will adopt the final constitution. Of course, like in Central Europe, the temporary stuff is the most permanent stuff. So until Orban, they've been functioning by using this amended communist constitution. But in the preamble to Hungarian constitution, the Orban ones, they say that this constitution is illegal. So the constitution which was offering the provision to adopt the new constitution in terms of new Hungarian constitution is illegal. But coming to the final point, the Central European tendency is to constitutionalize our communities by making these references and by using the references to the past. The legitimacy in the past is typical for all the states, and it's like a tendency which is raising. The example of Romania, then the example of Latvia. But of course, I fully agree with your question. If we take an example of German constitution, there is like an indirect memory narrative. I don't know, is there anything in Austria? I can see it in the constitution, which I just checked. But another example, the Iberian Peninsula, nothing in Spanish constitution, but they go from down to the constitution, because in Spanish constitution there is nothing about the memory. But Portuguese constitution preamble is full of the memory narratives about the revolution and anti-Salazar revolution. So this is my answer. It is autonomous decision of each political community at the moment of the constitutionalization. Thank you very much. And if I may ask a question, Professor Kamiński.
The first question from the audience.
Thank you very much indeed. Grauenberg from Institute of the Danube Region in Central Europe. I have a question actually concerning the Armenian genocide. It is quite some time ago, 1915. However, in 2013, there was a ruling of the European Court of Human Rights. An interesting case, a Turkish nationalist politician, he denied the genocide, and the Swiss court convicted him for that, and the European Court of Human Rights was against this conviction. However, the Armenian side said it was not denied that this genocide has happened. Now, in Turkey, even nowadays, when you say that has been a genocide, you get convicted 3 years or even more. And I wonder if that is not also a case for the European Court of Human Rights, that you get convicted because you're saying something, it was a genocide. Thank you.
May I say some words about the Austrian constitution? Last year we celebrated 100 years of Austrian constitution. And in 1945, in 1945, we took the constitution from 1920 in the version of 1929. And there is no connection with the Nazi, no reference to the Nazi past, but we have a Foundation Act, and there it is written, now we are standing before the ruins, and we are looking into the future, and we want to build a new democratic state, and all those people who committed crimes, Nazi crimes, should be aware that they are treated in a very severe way, and they have to stand trial.
And my question to Professor Kamiński, if I may, or because... there was... Yeah.
It's remained unanswered, so I think it was mostly addressed to Professor Kamiński, I guess.
Thank you very much for this question. I am very familiar with this Przed case from the European Court of Human Rights. It was it is a very controversial case. It's a very controversial, perhaps not case, but the judgment is very controversial. But anyway, the European Court of Human Rights in this case tried to differentiate, I would say, a pure denial speech from some reflection on the Armenian precisely genocide in terms of, looking for the reasons for the causes. So it was not for the European Court of Human Rights a clear denial of the Armenian genocide, but rather a voice of in a discussion around the Armenian genocide. I'm not very convinced about these judgments, so I would rather join the critics of this judgment. But anyway, in several legislations, national legislation, we have provisions dealing not only with speech denying the Holocaust, but also other cases of genocide. First of all, of course, the Armenian one. So it means that there are reasons in a national judicial system, several judicial systems for, instituting legal proceedings for those rejecting, denying the reality of the Armenian genocide. The legal perspective here is a bit complex because the concept of genocide itself, is post-war. But so the question is whether this legal concept could apply to some pre-war cases. We use the concept of genocide in relation to the Holocaust. We are ready to use this concept in the context of some other huge-scale acts committed against, for example, Gypsy or Roma communities. So we are ready to accept, you know, the application of this concept. So I think that, you know, the European Court of Human Rights might be confronted with very interesting, you know, cases. Might be confronted with very interesting cases in the future, and I am happy that, you know, there will be some job for the European Court of Human Rights also in this context.
Thank you. So we, so for it's like final, unless it is urgent and important, go ahead. If not, then we are actually well beyond time, and I think everyone deserved a coffee break. So I would like to thank our speakers and everyone who asked questions, and would like to invite you for a coffee break, and then we will meet for a second session. We are, well, actually half an hour past the time, so we will need probably to shorten a little bit the coffee break. So let's say, let's meet in 10 minutes, same place. Thank you.